Hi, I'm Emily and I am here with Maya Murphy's attorney, Ephraim J. Fink. Attorney Fink practices at Maya Murphy's office in Westport, Connecticut, and is admitted to practice law in both Connecticut and New York. My question today for Attorney Fink is, how do I know whether I need an expert for my personal injury case, and what kind of expert will support my side and testify on my behalf?
Thank you, and good question, Emily. Many cases require the testimony of an expert witness who will be able to determine either the liability of the case, whether there was fault, and the damage amounts. Expert witnesses are especially necessary in cases of wrongful death or medical malpractice because they are needed to prove liability or fault, as well as economic damages. For example, in a medical malpractice lawsuit, an expert witness in the relevant medical field will almost always be needed in order to demonstrate that the physician did not follow the standard of care. Further, a medical expert witness will be able to understand the complex medical facts of the case to determine whether the physician should be held liable for the injury. Connecticut requires well-informed disclosures of expert witnesses to the opposing party. This is not something that you can do right before trial. You are usually best off getting an expert early and upfront in the case to help you develop your case all along. I would like to break experts into three categories to talk about today. The first being liability experts. Accident reconstruction experts, engineers, architects, OSHA experts, biomechanical experts, building code specialists, and sometimes even doctors, as we just discussed, for a medical malpractice matter, are just a few of the types of witnesses who may have to testify at a deposition or a trial to assist a plaintiff's case and help the jury determine whether the defendant is liable for breaching a duty and causing the alleged injuries. The defendants are also allowed and will likely retain their own expert witness as well to contradict the plaintiff witnesses. This has been come to know what's known as in legal parlance as the battle of the experts. Experts provide the jury or the trier of fact with the specialized knowledge to better understand the case, the claims, and whether or not the defendant should be held civilly liable to the plaintiff or not. Sometimes parties may argue that a particular expert's specialized knowledge is not sufficiently known to the general scientific community, and therefore the expert should not be permitted to even testify before the jury. The second category of experts I would like to talk about is medical. Naturally, in a personal injury case, you have medical damage as a result of bodily physical injury. So in almost any personal injury case, the physicians, the doctors who treated the plaintiff, will play a vital role in helping to determine what the outcome of the case will be. Doctors are responsible for the injured person's diagnosis and prognosis. They are the only medical experts who are called upon that can provide the reliable evidence of what the actual injury was, how it was treated, and what the treatment, if any, may entail going forward into the future. Orthopedists, neurosurgeons, radiologists, chiropractors, even physical therapists can all be called as expert treaters of the plaintiff to provide a basis for the injury claim. Again, defendants are permitted to hire and present their own medical witnesses too. Remarkably, some trials have literally come down to and rested on competing, let's say, radiologists for each party telling the jury they do not see the same injury on an X-ray or an MRI film. One expert may argue that the injury was definitely caused by the accident at issue, whereas a competing expert may testify that the injury predates the accident and is a result of aging or a different trauma altogether. The other category of expert that I'd like to discuss today is what we call vocational or earnings-based. Economists, rehabilitation experts, actuaries, accountants, Each of these experts brings to the table their specific expertise in evaluating damages in a very critical area. These types of witnesses are often thought of as number crunchers, but they can be much more than that. They can interweave market analysis and forces to persuade juries what the future is likely to hold for an injured person's life, given past historic economic conditions. Sometimes these experts are asked by the parties or the court to determine if a person's skill set still allows them to transfer to another job that will have comparable wage and earning ability. The typical expert that is qualified to determine whether a plaintiff has sustained a loss in earning capacity is a vocational rehabilitation expert. This is also where expert testimony may play a role about retraining or new education that an injured person will have to seek to re-enter the job market. If you are unsure what kind of expert you may need for your personal injury case, please contact the litigation attorneys at Maya Murphy today.